We get asked a lot how long the probate process takes in Tennessee. And in Tennessee, we tell clients the probate process generally takes about 6 to 12 months, but that obviously can vary depending on the situation. To be clear, probate is the legal process where a probate court oversees settling a person's estate after they pass away. The court makes sure all debts are paid and all assets go to the right people. The probate process starts with the filing of the will with the court, there is one, and appoints someone to be in charge of the estate as well. That person is usually called the personal representative, but it's also sometimes known as the executor or the administrator in different situations. If the person has passed away within the past year, then after the estate is opened, there is a mandatory waiting period of at least 4 months in Tennessee. That's because the estate must be open long enough for that period to notify and allow creditors to file claims. And that creditor claims period is required even if the estate doesn't know of any creditors. So, even in the best case scenario, you're usually looking at a minimum of several months before the estate can be closed. But many probates don't even finish that quickly. If there are a lot of assets, creditors to deal with, family disagreements, missing documents, taxes to handle, or a complicated estate overall, the process can easily stretch out to a year or more. And remember, while the estate is in probate, assets are generally frozen or limited in use for a certain amount of time. That's required by law, but it can create delays or frustrations for families who need access to funds. So, to recap, most Tennessee probates take 6 to 12 months, sometimes longer, and it depends how organized things are, how quickly paperwork is handled, and whether there are disputes or complications that would extend that time frame further. And that's a reason many families, while they're still living and working on estate planning, look for ways to avoid probate, like preparing a living trust and or using beneficiary designations. And that's also something you can discuss with your attorney when planning your own estate.